Thank you, everyone, for the lovely smile and celebrating the 40th anniversary with Chambers. International arbitration has developed globally and certainly going strong. Arbitration has developed from an alternative dispute resolution to a preferred means of resolving disputes. Over the years, all the participants in the arbitration field has worked hard to ensure the effectiveness and efficiency of arbitration. For example, the Hong Kong court has introduced various measures to improve the recognition and enforcement of arbitral awards. And the HKIAC has just issued its 2024 administered rules to refine the rules in the light of the changing social and technology development. All these measures are in place for the better improvement of international arbitration. In the panel discussions, we hope that we can come together to take stock of what we have done so far, to see where there are untapped potentials of arbitration, and to find out the direction that international arbitration is heading towards. In the first panel discussion, we will look into the interplay between arbitration and corporate and insolvency disputes. With a round of applause, let's welcome our speakers and moderator. They are the Honorable Mr. Justice Jonathan Harris, Judge of the Court of First Instance High Court, Hong Kong SAR. We also have Patrick Fong, KC, SC. William Wong, SC. John Hui of DVC. We have Luke Chan Ho of DVC as our moderator.
Thank you, Sabrina. Good morning, everyone. So, as you know, this panel is about how to master arbitration in the context of insolvency disputes and shareholder disputes. Now, you may ask, why single out insolvency and shareholder disputes for arbitration? What is the difference between this type of disputes with normal commercial arbitration? This panel, we have a fantastic expert panelists here that will discuss these issues. Let me begin with one thought. You all have heard of why arbitration is used. We have heard quite a bit this morning about why arbitration and how arbitration has developed in Hong Kong and why Hong Kong has become an arbitration center. We all have known about or have learned about the benefits of arbitration, such as ease of enforcement with the use of the New York Convention, confidentiality, flexibility, and so on. In the context of Hong Kong and the mainland, we have the mutual enforcement. We also have the unique position of being able to get interim remedies to assist in arbitration in Hong Kong and in the mainland. So that makes Hong Kong unique as an arbitration center. But in the context of insolvency and corporate disputes, there is one angle which is even more unique. More unique in the sense that this is the only place where arbitration is most important in Hong Kong. All the benefits of arbitration that we have heard about in the context of commercial arbitration often do not apply or less relevant or are less relevant in the context of corporate and insolvency disputes. For instance, my experience is that in the context of insolvency disputes, the parties are more interested in using arbitration to limit judicial powers. It is fitting that we have Mr. Justice Harris here and also William Wong SC, both being judicial officers. Mr. Justice Harris, of course, is a full-time judge, and William Wong sits as a recorder from time to time. When I talk about judicial powers in the context of insolvency disputes, in Hong Kong, one is often dealing with winding up petitions. Hong Kong is unique in the sense that we do not have a dedicated restructuring regime. And as a result, practitioners need to cobble together solutions in order to achieve restructuring to deal with insolvency. And that's where the courts and the practitioners need to be quite creative in dealing with these things. As a result, arbitration becomes highly relevant in the context of restructuring. Now, at the moment, you might think that this is actually quite abstract. What do I really mean? And we will go on to discuss that. Now, I will begin with Mr. Justice Harris, because he is essentially the creator of the laws in this area, both in the context of arbitration of insolvency disputes and corporate disputes. And very relevantly, just 2 weeks ago or 10 days ago, the Court of Appeal has upheld in 2 cases the laws created by Mr. Justice Harris. So I will then begin with Jonathan so that he can talk about the latest position about how to use arbitration to deal effectively with insolvency and corporate disputes. Jonathan.
Thank you, Luke. I've had an interest in the interface between party autonomy in the choice of resolutions of disputes, and the regulation of companies, both solvent companies and insolvent companies, since the early 2000s. In 2001, I argued before Maria Yuan in Sky Datterman that priority should be given to party autonomy, in that case an arbitration clause, in a claim arising in a dispute between a building contractor and a developer. In the insolvency context, the court is normally concerned to determine, when hearing a winding up petition, whether or not the defending company has demonstrated that there's a bona fide defense on substantial grounds, and if that is demonstrated, then the petition is normally dismissed. And the issue in Sky Datterman was whether or not that issue should be determined in accordance with the dispute resolution provisions in the contract under which the debt was said to arise. I wasn't successful. I had another go the next year at persuading Mr. Justice Barmer in Jade Union. I wasn't successful then either. And that meant, I think there was an earlier decision of Mr. Justice Rogers Holmet, that the decisions at first instance were fairly clear, that the Companies Court took the view that if a company defending a winding up petition wanted to argue that the debt that was relied on by the petitioner was not in fact payable, it had to demonstrate in the winding up proceedings a bona fide defense on substantial ground. It couldn't insist that the matter went off to arbitration. And that remained the position until 2018, when I heard a case called Lasmos. Now, up until about that time, I'd rather taken the view that whatever my own personal views might be on the correct legal view, it wasn't open to me to depart from the position of obviously previous companies' judges. But what had changed was, before I heard Lasmos, I had heard a case referred to as Quicksilver, which was a shareholders' dispute. And by the time I heard Quicksilver, there was substantial English authority which suggested that in the context of a shareholder dispute where the shareholders' agreement or the articles contain an arbitration clause, a shareholder could insist on that form of dispute resolution resolving a substantial factual dispute between the parties before you could approach the court and ask the court to grant an unfair prejudice-like remedy. And in Quicksilver, I concluded that that was the position in Hong Kong because there was no alternative authority which suggested to the contrary. By the time I heard Lasmos, obviously I decided Quicksilver, and there was an additional English authority in the insolvency context, following on from the English authorities in the shareholder context, Salford Estates. And I thus felt able to reconsider the issue, and I concluded that, contrary to the earlier decisions, where parties had agreed that a dispute arising under a contract be resolved by arbitration, then when a debt was disputed, the parties were entitled to insist that the arbitration provisions were operated before the Companies Court was called on to consider whether or not a winding up order should be made on the grounds of insolvency. It's a little bit more complicated than that. You can read Lasmos to find out the wrinkles. That view, however, was not popular with everybody. I had at least one colleague who wasn't comfortable with it. I don't think William Wong was entirely comfortable with it, so people continued to argue in various cases whether or not this was the correct approach. Initially, the Court of Appeal declined to decide the issue when it was given the opportunity on the grounds that it wasn't necessary. They made a few type of not terribly helpful obiter comments. And then we had the Guy Lam litigation, which ended up in the CFA, which didn't concern an arbitration clause, it concerned an exclusive jurisdiction provision. And the CFA and the Court of Appeal took the Lasmos approach in relation to those provisions, but there remained some people who still weren't satisfied that the same was the case where the dispute resolution was an arbitration clause. And we had conflicting decisions at first instance for a little bit longer, until the Court of Appeal last month, I think it was, decided in Simplicity and Vogue and Shandong Chengming paper. Simplicity and Vogue was an appeal from my colleague Linda Chan. Shandong Chengming was a continuation of some rather torrid litigation that I've been dealing with for some years. That was one of my decisions. And the Court of Appeal took the view that it was clear that the Lasmos approach was to be preferred, and it applied both to original claims but also to cross-claims. And it seems to me that it's fairly easy to understand the justification for reaching that conclusion. It's quite important, I think, to appreciate that that doesn't necessarily mean that a company that's faced with a claim for payment of debt is necessarily going to be able to avoid the Companies Court's insolvency jurisdiction altogether at an early case, because it may well be, for example, there are other creditors. It may be there are cases where a party can legitimately issue a petition because an arbitration has not been commenced. And there may be issues concerning how the Companies Court should try and hold the ring where it thinks that there are serious questions as to whether or not a company is insolvent, despite the fact that the underlying dispute as to a debt should be determined by arbitration. That having been said, I think perhaps in practical terms, what's more interesting in terms of work for those of you who are interested in having work to do is the interface between alternative dispute resolution and the company's legislation in the solvent company context, shareholder disputes. It seems to me that arbitration makes sense as a mechanism to resolve shareholder disputes. I've dealt with a lot of those since I've been a judge. They tend to be messy. They're often family disputes. As a result, of course, commonly neither the articles or if there's a shareholders agreement, the shareholders agreement contains an arbitration clause, but that doesn't mean to say that the parties can't agree an ad hoc arbitration clause. And it seems to me the nature of the disputes probably will benefit from a more flexible form of dispute resolution, and arbitration is the obvious one to choose, I would have thought. So that summarizes very, very quickly the history of the interface between arbitration and the company court's jurisdiction, both over solvent companies where we are concerned with unfair prejudice-like cases and insolvency cases. We have a limited amount of time, so I won't keep talking, but I'm happy to answer questions if people have any towards the end of the session, or we can continue with a debate if there are people like William who still aren't convinced.
Yes, thank you, Jonathan. That is, of course, important, as Jonathan mentioned. In the context of shareholder disputes, arbitration offers the flexibility, especially to deal with very messy disputes. In the context of insolvency, arbitration sometimes can work to help a company avoid a winding up petition. That is important in Hong Kong because when you have a winding up petition, it makes it very difficult to conduct a restructuring. We can go on to talk about this after that. We should leave some time for Q&As later. But knowing the potential uses of arbitration in both disputes, ultimately arbitration depends on the agreement to arbitrate. Because without an agreement, there would be no arbitration. There can be no arbitral tribunal. So what the agreement actually says, in the first place, whether you have an agreement, and if you have an agreement, what the agreement actually says. Furthermore, what is really arbitrable in the context of insolvency and corporate disputes? These are all developing areas. So next, I'll turn to Patrick, who can talk about the latest developments on how we interpret arbitration clauses, arbitration agreements, because these agreements are often interpreted by both the tribunal and the court. Because knowing the way we could interpret arbitration clauses is very important, because it determines whether the arbitration will proceed, and if it proceeds, whether the award can be challenged. So Patrick, maybe you can shed some light on how we interpret arbitration clauses these days.
Now, there's no doubt that courts all over the world do respect the sanctity of autonomy of the parties and their agreement. I don't know whether the underlying motive behind that is that judges would welcome a chance to relieve themselves of their heavy workload so that the cases would go to arbitration rather than to the courts. Now, courts in many places of the world, especially those within the common law world, do respect the sanctity of the arbitration machinery. This can be demonstrated by what is known as the Fiona Trust principle, both in its original form and in its extended form. The origin of that principle is in a case by the name of Fiona Trust Holdings Corporation against Privilov, a case decided by the House of Lords in 2007. Now, that case concerned the jurisdiction and arbitration clauses in certain charter parties, which were in the following terms. First, it says, any dispute arising under this charter shall be decided by the English courts to whose jurisdiction the parties hereby agree. And then secondly, notwithstanding the foregoing, either party may, by giving written notice of election to the other party, elect to have any such dispute referred to arbitration in London. Now, the ship owners brought proceedings against the charterers for the torts of conspiracy, bribery, breach of fiduciary duty, claiming that each of the 8 charter parties had been induced by bribery And having rescinded the charter parties, the charters, the ship owners sought a declaration from the court as to the validity of the rescission and the validity of the charter parties on the basis that they had been induced by bribery. The charterers sought to have a stay of the court proceedings by relying on the arbitration clause. The matter reached the House of Lords, which held that there should be a stay in favor of arbitration. Now, Lord Hoffman decided to treat the provisions as a simple arbitration clause. And then he made his classic statement in his judgment. He says, in my opinion, the construction of an arbitration clause should start from the assumption that parties, as rational businessmen, are likely to have intended any dispute arising out of the relationship into which they have entered or purported to enter to be decided by the same tribunal. The clause should be construed in accordance with this presumption unless the language makes it clear that certain questions were intended to be excluded from the arbitrator's jurisdiction. Now, in the same case, Lord Hope referred to a US federal court case and an Australian federal court case and approved the following respective pronouncements by those courts. From the US federal court, it is said, federal arbitration policy required that any doubts concerning the scope of arbitral issues should be resolved in favor of arbitration, and that arbitration clauses should be construed as broadly as possible. And then from the Australian Federal Court, a liberal approach to the words chosen by the parties was underpinned by the sensible commercial presumption that the parties did not intend the inconvenience of having possible disputes from their transaction being heard in two places, particularly when they were operating in a truly international market. So, from those pronouncements, Lord Hope concluded that such approach to the issue of construction was now firmly embedded as part of the law of international commerce. So it is quite clear that in those various jurisdictions, the sentiment of the court was to respect an arbitration agreement as much as possible, unless there are indications, provisions to the contrary. Subsequently, the Fiona Trust principle was, in its extended form, was developed. In an English case in 2020, the Terre Neuve case, which was decided by Mr. Justice Bryan. In that case, he was dealing with a jurisdiction clause as opposed to an arbitration clause. But he held that the Fiona Trust principle will apply equally to a jurisdiction clause and an arbitration clause. He said that in cases subsequent to Fiona Trust, the generous interpretation to be given to jurisdiction and arbitration clauses had been extended to cover multi-contract disputes. in Fiona Trust itself, of course, there was only one single arbitration clause. This has been referred to as a principle which applies where two or more contracts are part of an overall package of agreements. Now, Mr. Justice Bryan set out 6 points about the extended Fiona Trust principle, which I summarize as follows. He was there contemplating the scenario of two contracts, contract A having an arbitration clause or a jurisdiction clause, and contract B with none of that. So he says, first, the principle is based on the construction of the relevant jurisdiction or arbitration clause in contract A, and is not based on implied incorporation of the jurisdiction or arbitration clause from contract A into a related contract B. Secondly, the wording of the jurisdiction or arbitration clause in contract A must be fairly capable of applying to disputes under contract B. Thirdly, it is not legally or commercially odd or improbable that an agreement should have no jurisdiction or arbitration clause, meaning contract B. Fourthly, this principle normally applies where the parties to contract A and contract B are the same. Fifthly, the extended Fiona Trust principle normally applies where contract A and contract B are interdependent or have been concluded at the same time as part of a single package or transaction, or if concluded at different times, deal with the same subject matter. And sixthly, a jurisdiction or arbitration clause in contract A will generally apply to contract B where the latter was entered into at the same or a similar time as contract A. So that is the extended Fiona Trust principle. And the Fiona Trust principle was reaffirmed by both the Supreme Court in the United Kingdom and by the Privy Council in two judgments which were delivered together in September 2023 in the cases of Mozambique and Family Mart. I think in those cases, the Supreme Court and the Privy Council also referred to the Quicksilver case, which Jonathan had which Jonathan decided in Hong Kong, and they certainly approved his judgment. Yeah. So in the Family Mart case, Lord Hodge said the following. He says, "From this brief review of international authorities, the board considers that there is now a general consensus among leading arbitration jurisdictions in the common law world that the domestic courts of countries that are signatories of the New York Convention respect and give priority to the autonomy of the parties to arbitration agreements. The statutory provisions of those countries provide for a mandatory stay of legal proceedings at the request of a party to an arbitration agreement when a matter in those proceedings is referable to arbitration. This is also a broad consensus on how to approach the determination of matters which must be referred to arbitration." So again, you have the highest court in the United Kingdom affirming this sort of approach to an arbitration agreement. Now, the Fiona Trust principle in its original and extended form has been generally accepted and applied by the courts in Hong Kong in a number of cases. The latest case on that subject is a case by the name of AAA against DDD, which was as recently as 2024 in February. The citation is 2024 HKCFI 513. It was decided by Deputy High Court Judge Reyes, who, as most of you would know, is a very experienced international arbitrator. In that case, he explained the principle of the Fiona Trust principle in detail, and also what is known as the center of gravity approach. And in that case, the issue before the court was whether the arbitration clause in a loan agreement would confer jurisdiction on the tribunal formed under it to determine related disputes arising out of a promissory note which had its own arbitration agreement. So I will not go into that because of the shortness of time, but it is a very illuminating judgment, and I recommend that you read it at some stage. Now, so it is quite clear that all the courts in most parts of the world will favor arbitration agreements. I think that's all I would say on this.
Thank you, Patrick. Now I turn to William. William, in one of your, in fact, the case that Jonathan referred to just now. Yes. William, the case that Jonathan referred to just now, where you disagreed with his judgment, the judgment that you wrote, where you disagree with Jonathan's judgment. Orbiter. Yeah, in Orbiter. Yeah. Yeah. So in your Orbiter reasoning, you mentioned that one of the things that could be decided via arbitration in the context of insolvency is disputes about proof of debt. As I mentioned just now, the concept of arbitrability in the context of insolvency disputes, even assuming that the arbitration clauses cover those disputes, is an evolving area. So would you like to shed some light on your current thinking on the state of law in relation to arbitrability of insolvency disputes?
Thank you. I think the starting point is that we have to note a critical issue of jurisdiction first. Because in a winding up of insolvency situation, as we know, it's a collective regime. It's a class action. Therefore, once a company is put into liquidation, we are not considering the one creditor who has filed a petition. We are considering the effective distribution of assets of that particular company, right? Now think of a situation where you have a subcontractor who has a contract with the main contractor, and in that contract there's an arbitration clause. But then the main contractor went into bankruptcy or insolvency, right? Now, according to our statute, once a company went into insolvency, as a matter of law, all proceedings will be stated unless the court uplift the state. The reason why the statute, our law, adopt this mechanism is because once a company goes into insolvency, the court is interested to ensure that there is a fair distribution of the remaining assets of the company to various creditors. Whereas a contract, including an arbitration clause, is nothing more than a contract between party A and party B. So that is the difference, and that is the struggle. So the key point is whether certain claims or certain reliefs are even arbitrable by way of a two-parties agreement, when that two-parties agreement would affect third party. Right? Now, let me give an example. Quicksilver and Jonathan's line of cases about shareholder dispute, unfair prejudice, just an equitable winding up, where you talk about shareholders, majority shareholders oppressing minority shareholders, misappropriation of assets, mismanagement, whatnot. All right? Now, in a normal course of event, we can go to court and we can file certain petitions, and those cases would funnel before Jonathan. And in the old days, there are quite a number of these cases, family disputes, family company disputes, etc. Now, there is a line of cases which says that, look, as far as jurisdiction is concerned, it is for the court to make orders for compulsory purchase. It's within the jurisdiction of the court to make order to wind up a company. The tribunal cannot make order to wind up a company. It's simply not within their power. And therefore, those proceedings by very nature are not arbitrable. Right? Since then, we have developed cases where, for example, in a case of a solvent situation, shareholder disputes, that, for example, the Fulham Football Club case says that it is arbitrable. Right? But still, the interplay is between a multi-party situation and a bilateral party situation. Because if, for example, the company has 50 shareholders, and you have only shareholders A and B enter into a shareholders agreement, which contains an arbitration clause, and you want to seek relief which would affect, for example, the winding up of a company, the other shareholders can say, well, I have a stake, right? I want to be heard, right? And I'm not party to the arbitration agreement. And therefore, why should my interests be affected by an arbitration agreement between two parties? So that's where the tension comes in, right? Now, as far as proof of debt is concerned, the law is very clear on two respects. One, in terms of submission to jurisdiction, because there used to be a line of cases that once you file a proof of debt, although your debt derived from a contract which includes an arbitration clause, then, sorry, you have submitted to the jurisdiction of the court, and therefore the effect of the arbitration clause is being nullified. Right? Now, that is being corrected by the English Court of Appeal, which says that the legal effect of submitting a proof of debt and a liquidator rejecting the proof of debt creates a dispute. Creates a dispute. It doesn't mean that you participate in the proceedings. So the law is very clear. The mere filing of a proof of debt is fine. Right? Now, the more tricky question is, under our company's ordinance, as I said, there is a definition that once a one-year petition is presented, all proceedings will be stated. Now, does the word proceeding include arbitration proceedings? The answer is yes. So arbitration proceeding is being included as the overarching proceedings under our statute. So arbitration proceeding would also be stayed if the subject company is being wound up, but subject to an important caveat, which is the power of the company to uplift the state, And the decision to whether to uplift the state depends on, the law says very clearly that the court has a wide discretion, right, to decide whether to uplift the state. For example, in a case of a construction dispute, right, it's very normal for a judge to say, look, this is a matter which I'm not competent to decide whether there is or is not a dispute. Right? It takes a whole lot of equal to a high court proceeding in order to determine that. And the parties, as far as this contract is concerned, the parties have a contractual mechanism of dispute resolution, which is arbitration. So the English line of cases says that you can uplift the stay, so that although you file a proof of that, you can then arbitrate, you can then determine the subject matter of the proof of that in an arbitration. So even in a case of a liquidation or insolvent situation, there is part of these proceedings which can be carved out and to be arbitrated. Right? So the overarching concept under common law, as far as I understand it, is the court want to be pragmatic about it. Right? Insofar as this matter, which can be, the asset test is which is the most cost-effective way of resolving the dispute. If the subject matter of the dispute can be resolved easily by way of an arbitration, then go for it. If it is actually the court which is more effective in resolving a subject matter of dispute, then the court should seize it and resolve it. And I think that demarcation makes perfect sense. Now, then if I may move on to another category, which is upon a winding up of company, liquidators normally takes out anti-avoidance proceedings. For example, unfair preference, avoidable transactions, trading at undervalued, fraudulent trading, and you want to set aside a particular transaction, right? Now, on that, there is a differences in judicial approaches. The English line of cases says that even in a case of anti-avoidance, i.e. unfair preference, misfeasance, whatnot, the court can encourage parties to arbitrate. Right. Now, but there is a recent line of cases in Singapore, starting with Larsen Oil and Gas, which says that as far as anti-avoidance proceedings concerned, they jealously guard that is within the regime and remit of liquidation, and liquidators are more capable or competent to do it, and therefore they have ruled that the Court of Appeal in Singapore has ruled that that is not arbitrable. Right. So that is an issue that remains to be debated. Now, as far as I move to my final point, as far as whether I was wrong in my decision, it comes down to this, right? And let's go back to the basics. If you have an agreement, right, the underlying agreement has an arbitration clause, right, and a petitioner presents a petition based on that. Lastmore says that if you have an arbitration clause, if you serve an arbitration notice, right, then let's go for an arbitration, right? I mean, that is almost a matter of routine, right? Now, but there is another school of thought, which I'm one of them, which says that one looks at the subject matter of the dispute, all right? Now, although you have an arbitration clause, you say there's a dispute, but if the facts before the court is that, look, a dishonored check, a case where clearly you have not paid your rent, right, and clearly there is no point in wasting resources of going to arbitrate because it would only delay the matter. And winding up, as I said, is a class remedy. All other creditors are waiting in the night. If a company is really insolvent, policy says that very clearly, the company should be put into liquidation as soon as possible so as to preserve its assets, right? So yes, you have the trump card of, I have an arbitration clause, right? Now, I have done a case, I've judged a case, but in a different context, the medicine case, where the defendant, through a contract in arbitration, with an arbitration clause, in his affirmation says, I have no defense. I might have no defense, right? But I have an arbitration cost, right? So I want to arbitrate. So the thinking behind is that, look, there is a policy consideration in the insolvency and winding regime, which is that you do not delay matters, and by the time you finish your arbitration, the assets of the company may be all been dissipated, and you are doing it to the prejudice of all other creditors. So if, for example, you have a clear admission of liability or a clear case where a judge looking at it, you can decide within 2 seconds that there is no possible or credible defense, why should the entire proceeding be stayed and you commence an arbitration and then a arbitration tribunal be constituted and then you wait for a few months for an award, right? So it comes down to that. The demarcation comes down to that. And the more strict, and now the prevailing view is that a contract is a contract, right? You have an arbitration cost. Although I have no defense, I have a dispute, and therefore go to arbitration. It boils down to that. And in fact, there are cases which says that, well, depending on the facts of different case, the outcome may be a bit different. Now, I can end with the concluding remark that recently I did a case where Mr. Morrow appeared before me. He wanted to seek winding up just an equitable relief in an arbitration. Soon he realized that that's not going to be done. But there is a mechanism where we can make finding of facts, right? We don't make the relief because the relief, for example, a winding up order, a buy order, that's remain the remit of the court. But as far as the disputed facts which give rise to relief is concerned, the tribunal is a body to make finding of facts. We can make a finding of facts A, B, C, D, and E. And then with that menu, then you go back to the court to say that, these are the facts which binds on the parties, issue a estoppel, you commence an arbitration, here are the findings. Based on these findings, court, I want an order, all right? I think Jonathan will welcome that approach because it means that he didn't need to spend days hearing arguments on family disputes or things like that, and he just need to decide on this set of facts, exercising my discretion, what is the order I should make, all right? So I think we have to be a bit more creative in a sense that we have to decide what sort of proceedings we can better use arbitration as a dispute resolution mechanism. I say this because, unfortunately, our court system is congested, and it takes time for dispute to be resolved in court. So it is in this context that arbitration comes in and can help resolve even disputes in insolvency. Thank you.
Thank you, William. I will give Jonathan a short opportunity to reply, but before that, may I turn briefly to John. I think John has some new thinking on how to develop some preemptive remedies on using the recent cases. If you have the time, maybe John can summarize your thoughts briefly.
Yes. Now, before you forget, this panel is about shareholders' dispute and insolvency. So the first part of my sharing would be on effective use of preemptive remedies in shareholders' dispute. Now, a typical scenario in shareholders' agreement would be that there may be terms containing appointments or removal of directors, or typically there will be some reserved matters where all shareholders must agree before the company resolve to do something, such as making a capital investment of over a certain amount, or even declaration of dividends, or typically dilution of someone's shareholding. Now, there are often disputes over, let's say, validity of appointment, whether it's someone is appointed as a director in accordance with the terms of the shareholders' agreement. And ensuing dispute would be whether that director is authorized to act, whether certain resolutions are validly passed, in accordance with the shareholders' agreement. And one camp of shareholders might threaten to act in breach of a shareholders' agreement. Now, and if that shareholder agreement contains an arbitration clause, then of course you'll have to go to arbitration to resolve those disputes. Now, in these scenarios, it is where preemptive remedies will become a very useful tool. Because very often your opposing party may just tactically want to force through something, to force through the company to do something and see how you react and see whether you can do something about it. And if what you can do is just start an arbitration, that might not help your client as an opposing camp of shareholder in the short term. So if you are able to use preemptive remedies such as interlocutory injunctions to prevent what you think is an unauthorized act from happening, then that will be a very useful tool. Because sometimes when your opposing camp sees that there is an injunction coming, then they might just lose interest in disputing with you altogether. Now, so how do we make use of that? Now, there are two routes typically in Hong Kong context. One is to start what we call the emergency arbitration procedure. That is very well entrenched in the Hong Kong IAC rules. It's in Article 23 of the rules, and their detailed rules are in Schedule 4. Now, the emergency arbitration procedure has all the hallmarks of an arbitration. First of all, it's confidential. No one can know about it. There's practically no court intervention, just like a normal arbitration proceedings. And sometimes the parties have a greater choice and autonomy over the procedure. You can adopt the rules, or you can make your own rules beforehand on what to do when the parties would engage in such a procedure. And also the decision of the emergency arbitrator would be less susceptible to an appeal or review, just like any other arbitration award. Now, but note that if you do not adopt the emergency arbitration procedure, let's say you go for the other route, which is go to the court to ask for an injunction, an order in aid of an arbitration. In some jurisdiction, this might be seen as a waiver of the arbitration agreement. So you might fall into the trap of waiving the arbitration agreement in obtaining the preemptive remedy, just to see that you will lose the chance to arbitrate the substantial dispute. But in Hong Kong, this is not the case, because our arbitration ordinance expressly provides that going for court interim measures would not be seen as a waiver. So no problem about that in Hong Kong, or in arbitration where Hong Kong is the seat. Now, the emergency arbitration is designed for urgency. The 2018 HKIAC rules provides that after the Secretariat accepts the case, then it promises to provide for an appointment of an emergency arbitrator within 24 hours. So that's pretty impressive. In an emergency arbitration, usually there will be only one emergency arbitrator, because it's not practical within 24 hours to have a panel of 3. But of course, if there is an agreement that there must be a panel of 3, that must be adhered to. And one important feature of the emergency arbitrator is that the emergency arbitrator would not sit as an arbitrator in the substantive dispute that ensues. So one tip is that if you have a favorite arbitrator in mind, don't appoint him as the emergency arbitrator, because you will lose him in the proper battle. Now, the emergency arbitrator may order what we call interim measures. It's not specifically defined, but it's thought that these are measures that maintain the status quo. So in the example that I've given, so if somebody tries to act as a director, then you can ask for an order or an award restraining him to do so. Now, the other avenue, of course, is to go to the courts under Section 45 of our arbitration ordinance. I'm sure you well know about these things, so I'm going to skip to very quickly to a second topic, which is food for thought, and maybe Mr. Justice Harris can give us some thoughts, which is that you all know about it's an insolvency context. You all know about you can apply for an injunction restraining a creditor from petitioning for winding up if you know that there is a dispute, a genuine dispute of the debt. Now, since we have re-simplicity, we have Guy Lam, can we ask for an injunction to prevent the presentation of a winding up petition if one party knows that the Guy Lam approach would apply had the petition been issued and the court would have stayed or dismissed the petition based on the principles in Lasmos as affirmed in Guy Lam. So that's, well, in the interest of time, I think it's better to leave it to the experts to give us some insights on that.
Yeah, thank you, John. I'm told we do not have time for Q&As, but judges must have the last word. So, so Jonathan, any last word?
A couple of quick points. I think the answer to John's question is probably yes. I can't immediately think why not. So far as William is concerned, as I say in paragraph 31, subparagraph 1 of Lasmos, the company has to dispute the debt. Obviously, if it doesn't dispute the debt, it can't just rely on an arbitration clause. And the second point is from a practical point of view, you have to have filed some evidence by the time you come before the judge, demonstrating that you are pursuing an arbitration. If you haven't, the court may take the robust view, I'm sorry, there is no evidence, I'm going to wind you up. And in cases where it seems to be clear that the debtor company is messing everybody around and hasn't filed any evidence, I would imagine that to be the kind of robust approach that you could frequently encounter, particularly from my colleague, who hears most of it.
Thank you. Thanks very much.